चलो
Yes, sir. Any mentioning?
Yeah, my lord, I beg to mention one matter. It is a
Ah.
public interest litigation by the villagers of Murshidabad, my lord. It is an
Uh-huh.
extremely urgent. The ferry service is completely blocked, my lord, because of the non-administration of the pathway leading to ferry. And then the ferry cuts is insecure for the people. That's why, my lord, they are scared to go through the ferry. The Jela police.
Have you served the notice, sir? Have you served
I've given
notice?
notice, my lord, and item 64 appearing in a lottery list on the last Thursday it appeared. May it be this Thursday, I shall give a further notice.
Yes, all right. We'll upgrade it.
My lord, may I kindly mention one matter, my lord?
Yes, sir.
This is on the point of admission in 2020. This has become virtually infructuous. So, Lordship,
Okay.
kindly let it come as to be mentioned. If your Lordship is so satisfied, then.
All right. But you need to give notice to the
I have
other.
already given sub notice. I have
It
already
is a, it's a group 9 matter, sir. It's a group 9 matter.
No, it's not group 9 matter. It is service matter. But although but in the
perhaps we do not have the determination with regard.
No, my lord, this matter has been filed in the form of public interest litigation. That's why, my lord, I am mentioning before your lordship, my lord.
Now, why do you say it has become infructuous?
Infructuous, my lord, the petitioner is not taking any action because it relates to the admission of 2 students in the year 2020, and now we are in 25. So, my lord,
you're appearing for the students.
I am appearing for the respondent, No.1 Vidyalaya, central government.
That is institution.
Yes.
All right. You give next week. Next week we will list it. Next week. Let the file be traced out. Huh?
My lord.
Yes,
I have served.
Lordship, may I leave to mention one more group 9 application for inclusion in the list?
Yes, please give. We will see.
Lordship, may I be permitted to mention one public interest litigation of the year 2019. This matter was specially assigned before the division bench presided over by Honorable Justice I.P. Mukherjee. Now this has not been assigned to any other bench. I'm just praying if it can be included
then
here.
What you do is you just give a letter to the OSD.
Yes,
Officer on special duty. I will administratively make the order.
Extremely grateful, Your Lordship.
Yes.
May I have my lord's kind leave to mention a matter?
Please.
My lord, this is a public interest litigation relating to series of unauthorized constructions taking place in one ward under KMC. Now, my lord, there was a direction during the vacation bench by Honorable Justice Ajay Kumar Gupta and Biswajit Basu directing the state authorities and the KMC to file a report within fortnight. Now, my lord, since the matter didn't appear, I mentioned before your lordship on 21st of November. And my lord directed the matter will appear on 28th, and I have served the other side as well. Matter didn't appear the last
because of my inconvenience.
My lord, I know. My lord, there is a new change that has taken place on 26th of November. After I have served my notice to the other side, 27, I was attacked by 3 or 4 goons. And I was told that you better withdraw this petition or else your family members will be in problem.
What you do is you file a supplementary affidavit, serve it on the state council also, and the private respondent, if any. Next week we will list it.
Lordship, I'm grateful.
But you bring it on record. And on
I'll do that, my lord.
I'll do that. Whether you have lodged a police complaint, etc., you bring it on.
I'll do that, my lord. Grateful.
Your Lordship, I beg to mention one public interest litigation, Your Lordship. The matter is regarding the unnatural death of 4 under trial prisoners at Bharuipur Correctional Home. Your Lordship, upon service, learned senior advocate Mr. Kaushik Gupta mentioned before your lordships, and your lordship directed the matter to be listed at the top of the list of the daily cause list for 28th of November 2024. But your lordship, the matter at that day, it was item number 146. So your lordship,
you please give the letter. We will get the file and do something. Okay.
Grateful, your lordship.
My lord, may I have your lordship kindly to mention this matter for inclusion in the list, my lord?
Yes.
My lord. Grateful, my lord. Grateful, my lord.
Yes, sir. Sir, please call.
Appellate side matter, item number 1.
Well, I am for the petition, my lord.
This petition arises from an order of the Honorable West Bengal Taxation Tribunal, my lord, which, my lord, on 2 points, my lord, my assessment order was passed, my lord, which is in page number 22 of the petition, my lord. My lord, one was that my gross turnover was arbitrarily enhanced, and the next was as regards to the ITC disallowed, my lord. ITC disallowed, my lord, if your lordship it takes up page number 22, my lord. There were five invoices against which ITC was disallowed, my lord. In 2 cases, no vehicle number was mentioned, my lord. ITC was disallowed. And in other 3 cases, my lord, no vehicle found. And in 1 case, my lord, the auto rickshaw was mentioned. Against which I went for an appeal.
The matter has been remanded to the appellate and revisional board, and the board was directed to call for the records within a time frame, and the board was directed to dispose it off. And what the board called for the records, approach of so and so on. So board shall revisit the order. Both parties shall be afforded an opportunity, pass a recent order uninfluenced by the stand taken by it earlier. Why are you challenging it now?
My lord, in 1 case, my lord, out of the 2, my lord, in 1 case, my lord, as regards to the enhancement of your gross turnover, my lord, page number 59, if lordship comes, my lord. My lord, from the bottom, my lord, six lines, my lord. 7th line, my lord. We direct the revisional authority to revisit the revisional order only on the point of estimation without any basis. Mr. Roy Chaudhary contention is that the input tax credit was disallowed without any reasons, is not borne in the order impugned. The reason has been specifically mentioned in the order itself, and it appears that the petitioner has not produced relevant tax invoices. My tax invoices at the time of assessment was produced, my lord.
Then you no.
My prayer is limited, my lord. Let this point also be revisited by the board, my lord.
Now, if you read page 60, it says that as if the remand is an open remand.
No, my lord. My lord, here the observation, my lord, the board, according to the board,
No, Mr. Churchurya, this operative portion of the order is only in page 60, where Mr. Chakraborty also will not object. It's an open remand. You see, otherwise, the board shall give both parties opportunity of being heard, shall pass a recent order uninfluenced by the stand taken by it earlier. That means the earlier order goes. They have to take a fresh decision. We'll clarify
earlier order, according to the board, earlier order in respect of
Mr.
the enhancement.
Wait, Mr. Tarba will tell. We will send it back. Let them revisit the entire matter.
Only thing, my lord, it's a case, my lord, would find just assessing authorities order just 1 page. I'll leave it to you, my lord. 22, kindly see. My lord, would find from the chart the goods were being carried in auto rickshaws, no vehicles were found. Page 22, my lord.
And what is the product? Steel, is it?
Scraps, scraps.
My lord, silicon sheets, my lord. My lord, if your lordship comes down, my lord, to the portion, my lord, above the box, my lord. Non-existent, and some has no capacity to bear the tons of silicon sheet, my lord. My lord, here, my lord, in this case, my lord, it means that the capacity in some cases, the vehicle was found, my lord. And these evidences as regards to this finding has not been given to me, my lord. And the law, my lord, as regards to the...
No. The onus is on the assessee to prove movement of goods.
My lord, I have filed all the documents, my lord.
How can you prove the negative?
But that I'll be filing before the board, my lord. Let it be considered by the board.
Right, all right. This writ petition has been filed, challenging an order passed by the West Bengal Taxation Tribunal, dated 24th July 2024, whereby the learned tribunal remanded the matter back to the West Bengal Commercial Taxes Appellate and Revisional Board for revisiting the revisional order. It is the learned advocate appearing for the petitioner does not have any grievance with regard to the order of remand to the revisional board, but is aggrieved by the observation made by the learned tribunal, restricting the remand only to the point with regard to estimation of turnover, which even according to the tribunal was not mentioned in the best of judgment assessment order. It is a settled legal position that the onus is on the assessee to prove movement of goods, and the assessing authority cannot be called upon to prove the negative. On perusal of the assessment order, we find that the assessing authority has found that some of the vehicles on verification from the database of the motor vehicles department were found to be non-existing, and some of them had no capacity to bear the quantity of silicon sheet alleged to have been transported. Therefore, it is for the assessee to establish by records that the records as well as vehicle number and other documents that the silicon sheets were being transported in those goods. Apart from that, the learned tribunal also noted that the writ petitioner has not produced the relevant tax invoices. This it is full stop. It is submitted by the learned advocate for the petitioner that this finding is incorrect, since at the time of assessment, the invoices have been submitted. As observed earlier, the entire onus is on the assessee to prove movement of goods, and if he fails to prove the movement of goods, then the input tax credit claim has to be denied. However, since the learned tribunal was of the view that the matter should be revisited by the revisional board, instead of restricting the order of remand only with regard to the estimation of the turnover, we slightly modify the order passed by the learned tribunal by converting the order into an open remand, whereby the West Bengal Commercial Taxes Appellate and Revisional Board shall revisit the entire revisional order and afford an opportunity of personal hearing to the assessee to produce all documents, and after affording an opportunity and after and thereafter pass a fresh order uninfluenced by the order passed by the appellate and revisional board, which was challenged before the learned tribunal. The appellate and revisional board shall issue fresh notice to the appellant assessee, writ petitioner assessee, directing them to appear on a particular date, on which date the assessee or their authorized representative shall appear in person, produce all documents, and without seeking for any adjournment, and thereafter the appellate and revisional board shall pass fresh orders on merits and in accordance with law. It is made clear that this court has not made any observations on the merits of the matter, and it is up to the appellate and revisional board to take a decision on the documents that may be placed before it. Next.
Item number 2.
I'm led by senior.
Yes, sir. Senior advocate, Mr. Siddiqui. Very good, sir.
Item number 2, my lord, I am appearing for the petition, my lord. But here my allegation is that the order has been passed against the principle of natural justice, my lord. My lord, if your lordship comes down to, my lord, page number 200 of the writ, petition, my lord, which is the assessment order, which is arising out of the draft assessment order which was served upon me, my lord. My lord, it very categorically says that
sent to the dealer submitted one objection against the draft.
My lord, the dealer is not carrying on business as a reseller, works contractor. They are only engaged in doing labor job. That the dealer is receiving contract and did the work of removal of overburden in various mines of ECL, and for the purpose for removal of overburden, the dealer imported plant and machinery, fuels and lubricants, my lord. My lord, hereinafter, my lord, an order was passed, my lord, upon which the demand was raised, my lord. Against this order, I went for an appeal, my lord. As per the
Hmm.
appellate authority, they gave me, and I did not pay the 15%, my lord. I went to the appellate authority without paying the 15%, arguing that as because the principle of natural justice has not been complied with, my lord, let this order be set aside, my lord. My lord, what the appellate order...
How can that be maintainable, sir? There is a statutory appeal and there is a pre-deposit condition. That condition has been upheld by the division bench. Several judgments are there.
My lord,
You need-
I'm admitting. My lord, let me complete it. My lord, I went to the appellate authority, my lord. The appellate authority heard it, but the order was not served upon me and passed. My lord, thereafter, my lord, for the service of the appellate order, my lord, I went before the tribunal, my lord. Now the tribunal, my lord, in spite of not having found the postal track record and report, my lord, as regards to service of this appellate order, my lord, my petition was dismissed, my lord. My lord, only limited prayer, my lord, let it be restored, my lord. I'll be paying that 15%. My lord,
No, you're not doing any charity, Mr. Chijoria.
No, my lord, admitted, my lord. My lord,
You are statutorily bound to. Now, what did the tribunal? Where is the reasoning of that?
Page number 222, my lord. The order starts in page number 220, my lord. My lord, 222, my lord. Even if the respondent could not found the postal track record, the statement made by the petitioner about the...
No. Page number is not tallying, sir. Annexure P5.
But in my copy, it has 120, 121 is off.
Yes. In my copy also 120.
120.
Anyway.
121. The third page of the order, my lord.
Third page of the order. Even if the respondent could not produce the postal track report of the statement made of the petitioner about absolute ignorance of the fate of the proceedings, so and so, completely belied with the document submitted. Statement made, and more importantly, impression sought to be created was inaction. Statements made by are not only without basis, frivolous, made to circumvent the statutory. Order passed in appeal, appellator stands to reason and regard being had to the legal position. No infirmity in the order calling for intervention. So also sought for submit the assessment itself improper, liable to be statutory form to ventilate 1 second has been dismissed for failure to make pre-deposit. Petitioner can exactly.
I admit it, my lord. I paid before the authority, my lord.
No, Mr. Sir, please show us the assessment order.
My lord, assessment order, my lord. Page number 200, my lord.
Computation.
200.
Computation is, my lord.
Page 199.
Page number
199 possibly. Computation is
202, my lord.
Our copy is 102.
Our copy is 202. At 203, 5 crores, 20 lakhs. No. 52 lakhs.
100,000, 10,000.
How much is the amount?
0, 10, 100,000, 10,000. 5 lakh 20,000, 510.
5 lakh 20,000.
No. Let's stand corrected. 0,
Sorry.
10, 100,000, 10,000 lakh, 10 lakh crore. 5 crore, 20 lakhs, 51,000, 15.
My lord.
5 crores, 20 lakhs, 51,000, 015. Now, how much is the interest, sir? No. The total tax due is 3 crores, 31 lakhs, 53,513. Correct?
My lord. And the interest is, my lord, 1 crore 88 lakhs 97,502.
We'll give you an opportunity, provided you deposit 50% of 3 crores 31,053. That will be treated as a pre-deposit also, and the appeal will be heard on merits.
But 50%, my lord. 15.
No. 50.
It will be.
You make reckless allegations against the department, and then that is why the tribunal.
No, my lord, my allegation as regards to non-passing of the appellate order, my lord, non-service, my lord, as because it was not served upon me, my lord.
That is why tribunal normally does not impose cost. In this case, it is imposed cost on you.
My lord, that is why I am stating, my lord, in page, it has been categorically recorded that no postal record is...
Now you know, out of this 3 crore 31 lakhs, 25%.
15% is the...
15% is for normal circumstances. Had you done that at the time of filing the appeal, it is fine. Now, if you want us to exercise discretion, because it is a not a regular writ petition. It is challenging an order of the tribunal. So in our discretion, you pay 25%. We will restore the appeal.
My lord.
All right. This writ petition has been filed challenging the order passed by the West Bengal Taxation Tribunal dated to 19th September 2023. By this said order, the tribunal dismissed the appeal filed against the order passed by the appellate authority, dismissing the appeal for non-compliance of the pre-deposit condition. The order passed by the learned tribunal cannot be faulted, as pre-deposit is mandatory and the writ petitioner having not complied with the same, the appellate authority was well justified in dismissing the appeal, as the appeal is no appeal in the eye of law. Full stop. However, we find that though the assessment order was passed by the sales tax officer Durgapur charge as early as on, sir, date is 29th June 2017. The said order has been still continued to remain a paper order, and the department has not been able to recover any taxes. The learned advocate for the writ petitioner submits that one opportunity may be given to the petitioner assessee to go before the appellate authority, and the assessee is ready and willing to comply with the pre-deposit condition. Under normal circumstances, the matter, the request might have been accepted, and the matter would have been remanded to the appellate authority. However, taking note of the conduct of the assessee in raising certain issues which, in the opinion of the learned tribunal, was frivolous, leading to the dismissal of the appeal before the tribunal with cause. We are of the view that discretion can be exercised in the assessee's case, subject to certain stringent conditions. As could be seen from the assessment order dated 29/6/2017, the total dues assessed, total tax assessed is rupees 3,31,53,513, and the interest rupees 1,88,97,502, and the total demand is rupees 5,20,51015. In order to afford one more opportunity to the writ petitioner, we direct the writ petitioner to pay 25% of the total tax dues, that is 25% of rupees 3,31,53,513 within a period of 6 weeks from the date of receipt of the server copy of this order. If the writ petitioner complies with the said condition within the time prescribed and produces proof of such remittance before the appellate authority shall restore the appeal to its file, hear the matter on merits, and pass a recent order. In the event the petitioner does not comply with the above condition within the time stipulated, the benefit of this order will not inure to the writ petitioner, and the writ petition would stand automatically dismissed without reference to this court. Next.
Well, within 6 weeks, my lord.
Yes.
Well, grateful, lord.
Item number 3.
This
Item number 3, my lord. I appear for the state respondents.
Application for continuation of delay 227 days.
227 days.
The revisional order was received for so and so. Motions. What is this, senior advocate, sir? 227 days.
My lord, I will not, my lord, because my lord, this will help us, my lord, when we come up before your lordship with 300 days, 400 days.
But here the tribunal has given some reasons, because they found that he had knowledge of that order.
It has been done, my lord. If your lordship kindly sees from the second page of the order.
See, the application was disposed of by the registrar of the concerned board with an endorsement that since one certified copy has already been issued and received by Shri Sharaf, the learned advocate for the petitioner, and so on. So there is no scope for issuing another certificate. All right. Now the matter has to go before the tribunal, is it?
My lord, again before the tribunal.
But who is appearing for the writ petitioner?
Mr. Shorodip Mujumdar. Mr. Shumit Ghosh, my lord, possibly will be appearing.
Where is Shumit?
No, he's not here.
All right, we'll say a passover. Let us see if he comes.
Item number 4. Next item number 4 is also similar. There is a delay of 222 days. Same petitioner.
Same petitioner, is it?
Same petitioner.
Or we can do one thing. We can impose some cost and where is the assessment order?
The assessment order, my lord, in item number 3.
But he has enclosed some death certificate.
Death certificate is at page 25 of assessment order.
Where is the assessment order?
One assessment order. The assessment order subject to correction, lord, it is at page 44. An assessment order, page 44. This is the form. This is the form.
Amount yet to be paid is 51 crores. 5 crores 15 lakhs 84,000 and odd. Where is his affidavit or a petition for condonation of delay?
Petition for condonation of delay. Page 18, 1/8, my lord. Starts from page 19, in fact.
This company is a government company, is it?
Basco Limited, my lord, it's not a government company. It is a company within the meaning of Companies Act. Russell Street is not a government company. Private, only the private management has changed, my lord, I think.
Okay.
The private management has changed. If your lordship kindly looks at the order.
But they are giving some reasons, sir. That in fact, of course, the time limit expired prior to the demise of the general manager.
My lord.
He passed away on 29th November 2022. Oh, correct. No. Time limit was there. All right, sir. We'll send it back.
My lord.
This writ petition has been filed. It's a both common order, is it?
No, my lord. It will be different because in the first writ petition it is 227 days delay, and the second one it is 222 days delay.
Okay, so separate order will pass, except for the this writ petition has been filed by the assessee, challenging the order passed by the learned West Bengal Taxation Tribunal, Calcutta, dated 31/7/2024, by which the application filed by the writ petitioner assessee for continuation of delay of 227 days in filing the application was rejected. After hearing the learned advocates for the parties and carefully perusing the reasons assigned by the learned tribunal, we find that the tribunal cannot be faulted for having dismissed the application after taking note of the facts and circumstances of the case, most particularly that a certified copy of the revisional order was issued and was received by the learned advocate of the foundry division of the writ petitioner. And therefore, the revisional authority stated that a second certified copy cannot be issued. Therefore, an officer. In the light of the same, under normal circumstances, we would have had no hesitation to dismiss the writ petition and uphold the order passed by the learned tribunal. However, considering the fact that the delay is 227 days and cannot be stated to be inordinate, and apart from that, the reasons which were set out in the application for continuation of delay were not found to be wholly false or palpably untrue. The petitioner has stated that one Mr. Raj Murari Podar, who was the general manager within bracket taxation, who used to handle all tax matters for the petitioner company, passed away on 29/11/2022 at the age of 72 years. However, the application before the learned tribunal could have been filed within 30th of September 2023. However, the company pleads certain difficulties which led to the delay. More particularly that a new person was recruited to the post of General Manager Taxation on 1/1/2024, and by that time, the limitation to file the application before the tribunal had expired. Thus, considering the peculiar facts and circumstances and taking note of the fact that the conduct of the writ petitioner cannot be stated to be wholly without any bona fide, we are inclined to exercise discretion in the matter and condone the delay in filing the application before the learned tribunal. Accordingly, the writ petition is allowed, and the delay in filing the application before the learned tribunal is condoned, and the learned tribunal is requested to decide the matter on merits and in accordance with law.
Grateful.
Yes. Sir, the next item also, same order, except the delay will be 222.
That is item number 3.
Yes.
Item number 3 will be 227 days. Item number 4 will be 222 days.
Yes, sir.
My lord. Before your lordship takes up the next matter, my lord, our best wishes and for the good health of my lord's father, my lord. We do not know how is he now. But
no, he is now actually slowly sinking.
No.
He is not responding. He is not able to identify me also. For 3 days, I was in the hospital. Today, I have come back. And doctors have advised that we take him home with oxygen support. There's no food and no water for the past 72 hours. He's suffering. That's very sad to see.
Very sad. Very sad.
He is a very renowned general surgeon. He was a professor of general surgery in Madras Medical College. And in fact, the hospital where he is admitted, all the doctors who has put up that hospital is called Prashant Hospital. They have got 3 or 4 hospitals. In fact, my son is also a robotic surgeon in the same hospital. And they are all his students. The chairman of the hospital, the chairman's wife, she's also a doctor. And he has developed so many people, so many patients in the government hospital. When I was an advocate, I used to be all staff members of the High Court. used to be treated in the government general, like SSKM. It's called, it was earlier called Government General Hospital, opposite the Madras Central Railway Station. Now it is called Rajiv Gandhi Government General Hospital. All of them used to be treated. Hundreds and thousands of people in a government hospital, very good treatment. He has brought up so many. And to see him like this, it's very painful.
It's very
So,
no doubt.
all the time
we can all pray for him, my lord, because for any human being, their parents, my lord, they are the best companion, the best friend, everything, my lord. My lord, we can all understand that. We can all pray for him, my lord. May God give him good health.
Thank you. Thank you. Next.
Item number 5.
My lord, I am for the petitioner in this matter.
Very good.
This petition is actually against the rejection of my supplementary affidavit by Honorable Taxation Tribunal. My lord, the matter goes like this, that being aggrieved by an order of the West Bengal Commercial Tax and Appellate Revisional Board, your petitioner filed an application before the Taxation Tribunal, firstly on 03/09/2021.
What do you want in the supplementary affidavit?
My lord, there are some new documents that has been recovered, and according to that document, a new ground of defense has been raised.
Okay.
So, on as this matter was firstly taken up by the Honorable Tribunal on 22/01/2024, that day Honorable Tribunal allowed me the liberty to file the supplementary affidavit.
But that was 7 days time was granted.
My lord, thereafter, my attorney who was responsible for this particular petition was a cancer patient, and subsequently he expired. And I have specifically mentioned that point in the supplementary affidavit.
Which
my
paragraph?
lord, could kindly consider that after, my lord,
page para.
My lord, that is in page 23. I have annexure, and that is the annexure supplementary affidavit, the page 23, running page 23, your lordship. Running page 23.
No,
the lordship found
from page 22 bottom.
Starting from 22 bottom, my lord.
It is worth mentioning in this regard, the Sushil Kumar Jain, who entrusted the duty of keeping all the records suffered from wrong, ultimately passed away during May 2024. It became difficult for the petitioner to fish out all documents, delay in filing supplementary affidavits. All right. Now, the tribunal passed the order on
1709.
No, please hear me and then respond. On 29/7/2024. Okay?
My lord.
It granted you liberty 7 days time. When was the next hearing date before the tribunal?
My lord, the next hearing date was 29/07/2024.
29/07/2024.
17/09/2024.
17/09/2024.
And I filed this supplementary on 29/07/2024, 2 months earlier. 29/07/2024.
Direction for supplementary affidavit, 22 January.
Sir, on what date?
That is possibly your lordship is looking at 22nd January 2024.
22nd, right. So 22nd January 2024, the tribunal granted you liberty to file supplementary affidavit.
My lord.
You within 7 days, but you filed it after 70 days.
My lord.
That is on 29/7. But in between 22nd February 2024 and 17/9/2024, there was no hearing of the matter?
No, my lord. No, my lord.
Then Mr. Siddiqui is senior advocate. Then we'll accept. We'll accept.
My lord, in the meantime, there is one more addition, actually, that they have also filed the reply affidavit in opposition. The authority has filed the affidavit in opposition in this regard. That could not be taken in this petition because after the petition was filed, that reply was.
In the affidavit in opposition, in the affidavit in opposition, have they dealt with your new
points
ground?
Of the main argument. Points of the main petition.
All right, you hear the order. This writ petition has been filed by the assessee, challenging the order passed by the learned West Bengal Taxation Tribunal, Kolkata, dated 1/10/2024, by which the learned tribunal declined to take on record the supplementary affidavit filed by the writ petitioner assessee on 29/7/2024 on the ground that it was filed well beyond the time granted by the learned tribunal by its order dated 22nd January 2024. Such discretionary orders will not be interfered by this court, more particularly when it is a statutory tribunal. However, one fact which has persuaded us to take a slightly different stand is that the learned tribunal, learned tribunal in its hearing held on 22nd January 2024 had granted liberty to the writ petitioner assessee to file a supplementary affidavit within 7 days. However, the petitioner assessee did not file it within 7 days, but filed it on 29/7/2024. That is after nearly 7 months. However, the matter was taken up for hearing by the learned tribunal only on 17th of September 2024 and not earlier, on which date the impugned order came to be passed. Therefore, we are of the view that the supplementary affidavit can be permitted to be taken on record with liberty to the department to file their affidavit in opposition. The learned advocate for the writ petitioner assessee submitted that during the pendency of this appeal, the department has filed their affidavit in opposition to the original application filed by the assessee before the learned tribunal. Since we are of the view that the supplementary affidavit should be permitted to be taken on record, we accordingly direct the learned tribunal to permit take the supplementary affidavit on record and grant reasonable time to the respondent department to file their affidavit in opposition, and thereafter take a decision in the matter on merits and in accordance with the law. It is made clear that this order has been passed taking into consideration the peculiar facts and circumstances of the case and not to be treated as a precedent. Next.
Grateful, Your Lordship.
Yes. Item number 6. Who is this? Commissioner of Central Goods and Service Tax, Kolkata North. Where is Tapan Banja?
Middle term.
Lordship, this appeal was filed by Mr. K.K. Maiti. Lordship, will take instruction who has been engaged in this matter, Your Lordship. Wait,
let us see what is the order. This order was passed sometime in July last year.
Yes, Your Lordship.
Petitioner has filed this application agree with action asking the petitioner to make payment of late fee in filing the return in consequence of the restoration of the registration. The respondent is asking petitioner to pay 10,000 for filing each return for the relevant period. That petitioner has already paid 21,000 as late fee. Upon payment of the said and some of the periods, petitioner has been allowed to file return, but the remaining period they are asking for payment of huge amount without any authority of law. The learned advocate of petitioner support relies on underput decision of division bench of this court in Modicom Enterprises, MAT 1823, 28 of 20, relevant para 8 and 9. Appeal and connected application disposed of restraining or demanding late fees, so and so. Direct necessary. Needless to say that the ground of a non-filing should not initiate fresh proceedings for cancellation. Maiti learned advocate appearing for the respondent could not justify such action concerning asking the person so and so. He also fairly submits that in view of the aforesaid judgment of the division bench, authority concerned cannot ask for the amount it has asked for. Considering the facts and circumstances of the case, aforesaid order of the division bench of this court disposed of directing to allow the petition so also without payment. Aishwarya, this 21,000 rupees they are filing this appeal.
Yes, Your Lordship. Writ petition, I was there, Your Lordship, but in appeal, I have not been engaged, Your Lordship.
We will engage you today.
Lordship.
We have heard Aishwarya Rajshri, learned advocate appearing for the appellant department. We direct her appearance to be regularized and her fee bill to be honored. Para. This intra-court appeal by the department is directed against an order passed, order dated 27/7/2023 in WPA 168/30 of 2023. By the said order, the learned single bench, after taking note of the facts and circumstances of the case, as well as the decision of the division bench in MAT 1828 of 2022, had directed the department to allow the writ petitioner to file returns in question relating to the relevant period without payment of any late fee. Before the learned single bench, the department was not able to show that the department was unable to controvert the submission of the writ petitioner, that the division bench, the order passed by the division bench would apply to the facts and circumstances of the case. Thus, we find no grounds to interfere with the impugned order. Appeal dismissed. Thank you.
Obliged.
Item number 7.
Limtown Metals. Yes, Mr. Banerjee.
My lord,
Yes,
I'm appearing in this matter, my lord. I'm the petitioner, my lord. My lord,
happened?
in this, I have come against the an appeal against the order of the single judge, my lord, who has dismissed my writ petition, my lord, on the basis of a submission which I have made. My lord, my case before the single bench was that my registration, the petitioner's registration, my lord, the petitioner is a limited company and he is a compliant company, my lord, and it will appear from the Ministry of Corporate Affairs at page 67 that he has filed all his data and it is said he is active and compliant. Now, my lord, his registration was previously, my lord, he was in Kolkata, and thereafter the company shifted its place to 24 Parganas. Now, my lord, the show cause notice I had challenged because, my lord, it does not disclose any reason why the registration.
That's the mistake you did, Mr. Mukherjee.
Yes, my lord.
By challenging the show cause notice. You should have taken liberty from the learned single bench that to go before the authority and raise and then take the normal course.
My lord, no. I have submitted a reply. My lord, I will just take your lordship through the show cause notice, my reply and their order. My lord, not a single ground why my registration will be cancelled.
Madam, you please show the impugned with the order which you challenged in the writ petition.
Yes, my lord.
Page
78, my lord. 78.
This is why you're bypassing this. You're taking a risk, madam.
My lord, kindly see the order, my lord. This is reference to show cause notice, page 78, my lord, of the CAN application. My lord, this is reference to show cause notice dated such and such. The effective date of cancellation of a registration is 18/12/21. My lord, no reason at all. And my lord, so what I submitted before.
Now, under the provisions of the Act, can you not file an application for revoking this order?
My lord, I could have, but if he had given me any grounds, my lord, kindly come to the show cause notice, my lord. Kindly come at page 69. My lord, it says, my lord, whereas on the basis of information which has come to my notice, your registration is liable to be cancelled for the following reasons. Others. My lord, nothing there. And only says, my lord.
Mr. Banerjee, this is the height of arbitrariness.
My lord,
this is the prescribed format, my lord, as per the.
All right. Here also Vakalatnama is also prescribed format.
Yes,
but if you don't file the name, fill up the name of Mr. Banerjee and Banerjee doesn't sign, doesn't fix the required stamp, whether Vakalatnama is a valid Vakalatnama.
My lord, during the trial proceedings, my lord, your lordship will kindly see the internal page.
This is all because the power goes into their head. Taxation authority. Yes. Assessee is my subordinate.
No, my lord, over here, there were panchanamas indicating that physical verification of the registered office was taken and it was found to be fictitious, which he has already annexed, which we have demonstrated in the before the writ court. Lordship may kindly turn to page 23, that is before paragraph number 7, wherein the Honorable Single Judge gave liberty that you give us opportunity for further inspection.
My lord.
But they declined.
No, it is not, my lord.
Well,
not,
that is the observation of the court. It
I'm
has not
stating-
No,
applied.
madam, page 70 onwards are the enclosures along with the show cause notice.
Yes.
And
Yes.
you have sent your reply at page 76.
Yes,
Huh?
ma'am.
Followed by a
Yes.
email 77.
E-
So let him
70
decide. Let him decide.
Yes.
My lord, 76, I have
And
stated,
Lordship
my
will
lord.
kindly see from the
Mr.
Panchanama, we have
But that is
demonstrated
not
in what manner the officers have gone and found that the address is not. This is
No.
just a fly-by-night customer.
My lord, what I stated.
Page number 78
Yes, my lord.
is not a speaking order.
My lord.
No, number one. Number two, it is an order cancelling the registration with retrospective effect. In the interregnum, if the assessee has filed returns, he has availed input tax credit.
Yes.
By retrospective cancellation, you will try to reverse all the credit which he has availed. So that will be very, very, hard on the assessee.
Yes,
so therefore,
my lord, but the ground, my lord, I'm just interrupting. My lord, this is what a honest taxpayer would have been done, and this would be the correct approach, what your lordship is now observing. Yes, an honest taxpayer, if he has done something wrong or has not complied with some non-deliberate attitude, then it is fine. But over here, my lord, series are such companies are floating herein and day out, and they are doing all sorts of business without following the statutory guidelines or the statutory mandate.
We will not do anything. We will send it back to the this chap, who's that officer, range officer, Superintendent Lal Bazar. He will pass a speaking order.
Yes.
That's it. We won't restore the registration, etc. Because if he is so bad a person, then he
let
can't
him consider. Let them say what they had to say.
What grounds they have cancelled, my lord?
All right. This intra-court appeal by the writ petitioner is directed against the order dated so and so and WPA so and so. In the said writ petition, the appellant had challenged an order of cancellation of the registration under the provisions of the CGST Act 2017, primarily on the ground that it is in violation of principles of natural justice, devoid of reasons, and unsustainable in law. The learned single bench had disposed of the writ petition with certain observations. As could be seen from the records appended to the appeal memorandum, appeal, a show cause notice was issued to the appellant on 19/1/2024. Along with the show cause notice, the department enclosed a communication received from the Assistant Commissioner, Headquarters Anti-Evasion, CGST and CX, Kolkata North Commissionerate, addressed to the Assistant Commissioner, BPT Bagh, Roman 2 Division, CGST and CX. There was also a copy of a Panchanama drawn on 29/3/2024. No, sorry. Panchanama, wherein there were certain allegations. The appellant received the show cause notice and submitted the reply on 31/1/2024, followed by another email dated on the same date. The authority has passed an order dated 31/1/2024, retrospectively cancelling the registration of the appellant. We find from the format of the order, which is in form GST REG-19, numerical 19. Sorry, passed the impugned order dated 1/2/2024.
Yes, my lord.
In form GST REG-19. However, the statutory format does not give any reasons as to why the appellant's registration has to be cancelled, that too with retrospective effect from 18/12/2021. The assessee would state that they have not received any enclosures along with form GST REG-19. This submission is taken on record and based on which the following order is passed. Para. As the assessee has submitted a reply to the show cause notice, It is for the authority to consider the reply and then record reasons in writing and either accept the reply or reject the contentions raised in the reply to the show cause notice. Therefore, full stop. In other words, the order should be a speaking order. Apart from that, the authority should also give reasons as to why and for what, as to why the registration should be cancelled with retrospective effect, as such cancellation may result in other civil consequences. Therefore, we dispose of this appeal by setting aside the order dated 1/2/2024 in form GS REG-19 and remanding the matter back to the original authority, who is directed to afford an opportunity of personal hearing to the appellant assessee, peruse the documents that they may produce, and take a fresh decision on merits and in accordance with law. If necessary, if in the opinion of the authority, personal inspection of the place of business is required, he may do so, and it can also be a surprise inspection. Surprisingly, this discretion is left to the authority. This discretion is left to the authority. With the authority is directed to fix the date for personal hearing within a period of 2 weeks from the date on which the server copy of this order is received by the department. Next.
I'm grateful, my lord. My lord, we are much obliged for your lordship of hearing us, my lord, despite the difficult and critical times.
What to do?
My
I
lord.
wanted to come yesterday morning, but
Yes, my lord.
charges were prohibitively high.
We are extremely obliged and grateful.
Yes,
Item number 8.
What is this, madam?
Well, this is an appeal against the writ court's order, whereby they had challenged the show cause cum demand notice, but ultimately it merged with the adjudication order, which was not challenged in the original writ petition. Well, they are praying for time.
My lord, Mr. Debru Bhattacharjee is engaged in the matter. My lord, due to personal difficulties, he couldn't come to court today. So he has asked me to seek for an accommodation, your lordship.
When do you want? Next week?
Yes, my lord. Kindly keeps it next
All
week.
right, the request of the learned counsel for the appellant next week. Next.
Item number 9.
May I please, your lordship, I am for the appellant. The outside lordship, I have challenged the section 147 order. I know your lordship's thumb rule of not interfering in such orders, but lordship kindly hears me out. This is a very peculiar case, lordship, that I'll beseech. Lordship, the only point involved is that the assessment is
Have you served Mr. Tilak Mitro?
Lordship, I have served the respondents, my lords.
You served notice of Mr. Mitro. He appeared.
Because they asked us to serve the directly to them, so we've served, lordship.
Yes. That affidavit of service will take on record.
Lordship.
We have heard the learned advocate for the appellant. Notice has been served on the respondent department. In addition, we direct the learned counsel for the appellant to serve Mr. Tilak Mitra, standing counsel, who appeared for the department before the learned single bench. List the matter next week in the admission list. Please do it today.
I'm obliged, lordship. I'll do that.
Great. Item number 10.
Yes, sir. Mr. Kant.
My lord.
Interpretation. Amendment.
GST button.
You had to question the jurisdiction of the deputy commissioner to issue show cause notice.
My lord, that is one thing. The main issue, this matter arose from an order passed by adjudicating order authority under section 74, denying me ITC of 1.37 crore rupees. The allegation that the registration of my suppliers had been cancelled with retrospective effect. That's the only allegation. They have not undertaken any investigation at the seller's end.
That is required, no? As per our order also.
Suncraft.
Suncraft.
Yes, Suncraft, LWG.
Suncraft is with regard
the
to
latest.
Suncraft was upheld by the Supreme Court.
Supreme Court.
And did you not place the Suncraft judgment before the single bench?
This hearing before the honorable single bench took a different course, my lord. There the issues was approached from a different angle, and somehow all these points did not get discussed, though some of them were definitely in the writ petition filed.
But you did not appear, that's the problem.
I did not appear, my lord.
Ghosh was there.
Ghosh was there.
My lord.
Then we will follow Suncraft and remand the matter.
Yes, my lord. If instead, if I had been relegated to the adjudicating authority, I would not have come before this honorable bench, my lord.
And what is the citation, sir? Suncraft reported.
Citation.
Suncraft is 117 GSTR 78 Calcutta. This is a high court. And then there is 2023 SCC.
All right. Now you give that copy to the our
my lord.
AR court. So he will they will take down.
Well, subject to correction, my lord, if your lordship kindly comes to the adjudication order which is appearing at page 79.
75 se shuru.
79 is the text of the order. My lord, if your lordship kindly sees from the last paragraph at page 79, here recipient AK Enterprise, that is the petitioner before your lordship, has procured tax invoices purportedly in order to avail ITC from the above suppliers who were never ever existed. Actually, no such supplies transactions listed in the above table have ever been effected, as no physical movement of goods has ever been took place from that the purported suppliers are non-existent at the respective place of business since date of registration. Next page, my lord, since the suppliers never existed at the declared place of business, I have reason to believe that all the above mentioned transactions did not take place as per the scope of supply under section 7 of the Act, and hence the recipient taxpayer is not eligible to claim input tax credit as per conditions laid down in section 16(2). Since the supplier never existed, it is hereby concluded to the best of my
Now
knowledge.
we will accept it, Mr. Siddiqui.
But Suncraft pilots, they existed. So Suncraft is not applicable in this particular, subject to correction, my lord. They existed. There was a mismatch between GSTR and 2A and 3B in Suncraft.
No, that is one issue. But that there are other decisions of the Madras High Court also, as well as Delhi High Court and Bombay. The department makes its own verification on the supplier end.
My lord.
They open the portal, etc., and they find that, let us assume, the 10 suppliers registration cancelled. This person says that I have purchased goods from him, and these are the documents to prove movement of goods, and this is my claim for ITC.
Right.
If you make a verification in the other end and find that the supplier to be non-existent, then the purchasing dealer, he should be put on notice with that information. He should be able to controvert. So therefore, there are other decisions, Mr. Khan. One division bench, that is, I forget the name of the cost title. I remember the name. The senior judge is R. Sudhakar.
One judgment is Loknath Construction by this honorable bench, my lord, which follows Suncraft.
No. I'm telling, other than Suncraft, there are a couple of decisions which will match your facts. Next week?
We'll come back on the next week. We'll come back on the next week.
In the meantime, any course of action is taken?
No,
we have not taken, but your lordship may kindly pass direction to that. We will not take any course of action.
All right. The issue to be considered in this appeal is whether the decision of this court in Suncraft so-and-so, reported in so-and-so, which was affirmed by the Honorable Supreme Court in so-and-so, would be applicable to the facts and circumstances of the case. The question would be, no, full stop. The assessing officer was of the opinion that the appellant is not entitled to avail ITC in respect of certain transactions done with 9 suppliers who, in the opinion of the assessing officer, were non-existent, and the assessee did not prove movement of goods, and that the suppliers' registration were cancelled on the ground of fraud, willful misstatement, and suppression of facts. The question would be, if this was the view taken by the assessing officer, should the assessee before us, who's the purchasing dealer, should be supplied with the information based on which the assessing officer came to the conclusion that the selling dealers are non-existent and their GST and registrations have been cancelled. Since the matter requires consideration, let the matter appear in under the same caption. You give a date in the first or second week of January. All right. So and so. Full stop. Since the legal issue has to be decided, we direct the respondents not to initiate any coercive action against the appellant pursuant to the orders passed by the department.
Definitely.
Yes. Next.
Item number 11.
11.
My lord, I'm appealing for the petitioner, lordship. The appellant.
Yes, sir. Yes, Mr. Bhattacharya.
My lord, yes. Lordship, the matter is a very small, minusculatic matter. What has happened here was there was an order for refund by the appellate authority, and the refund was not forthcoming. So I came before the Honorable Read Court for praying for a mandamus that kindly issue my refund along with interest. That was my prayer. Now, my lord, in the meantime, the taxation tribunal had reopened. So although I filed the supplementary affidavit, I made a humble prayer that the matter may be released, because the Read Court in such a circumstance does not have the jurisdiction, my lord. But all of a sudden, the question arose that whether I have the power to make this instant application or not. It's filed by a liquidator. I have annexed all the documents of the liquidator. But in my humble submission, my lord, even when there is no jurisdiction, whether it is rightly or wrongly
no,
filed,
you could have withdrawn the petition with liberty to.
I wanted to do that only, my lord. But unfortunately, the matter took a different course altogether.
No. That will permit Mr. Tanmay Chakraborty.
My lord, with deep respect to my learned friend, my lord, the matter was taken up twice. In the first day, the court asked us why should not the refund be given. He agreed to it. He did not object.
No, I said.
No, my lord,
the court could not.
I have not
Even the
objected.
court could
In
not.
the second day,
could not.
when the court
does
had
not have the
asked him
jurisdiction.
certain queries that when the liquidation has taken place, because there are, my lord,
All
we have
right,
certain.
sir. Why all of us should break our head with this? Let him go. Now that what is the tribunal called?
West Bengal Taxation Tribunal.
Now that is fully functional. So what we'll do is we will dispose of the writ petition and this appeal, permitting the appellant to raise all issues before the learned West Bengal taxation. We have elaborately heard Mr. Bodhian Muttachari, learned advocate for the appellant, as well, and Mr. Tanmay Chakraborty, learned
Tanmay Chakraborty, my lord.
Chakraborty, learned advocate appearing for the respondent state. After considering the submissions on either side and carefully perusing the materials on record, we are of the view that the issue raised in this appeal as well as in the writ petition have to be raised before the appropriate forum, namely the learned West Bengal Taxation Tribunal. It is seen that the writ petition, when it was filed in the year 2022, at that time the West Bengal Taxation Tribunal was not functional. As of now, the learned tribunal is fully functional. Therefore, we are of the view that the writ petitioner appellant should be permitted to the learned West Bengal Taxation Tribunal and raise all plea before the learned tribunal. Accordingly, the impugned order is set aside and the writ petition as well as this appeal are disposed of, giving liberty to the appellant to raise all issues before the West Bengal Learned Taxation Tribunal.
I'm grateful to my lord.
Yes.
And my lord,
Next.
I express my deepest respect and regard for your lordship. The way your lordship is conducting today, I can very well understand your lordship's mind. And it's a deep respect to your lordship and to your lordship's father. I pray for his good health.
Thank you very much.
My lord.
Next.
My lord, we are also at liberty to raise all points, including the maintainability.
Please add one line. It is needless to state that the respondents are at liberty to raise all issues, both legal and factual, before the learned tribunal. Next.
Item number 12.
But I beg to appear for the appellant.
What is this, Himanshu?
My lord, with greatest respect, my lord, learned single judge gave liberty to file a statutory appeal with pre-deposit 3 lakh, but actual pre-deposit 1,10,000 and lifted the bank attachment. Here, my lord, I am challenging.
Why the learned judge said 3 lakhs? Because you appeared in the matter.
Because, my lord, I filed lately, my lord, because I missed the all notices, my lord. My petitioner number 2 years, 100% defend dam cannot travel without escort, my lord.
No, Himanshu. Your client was in a position to engage 6 advocates. Himanshu Kumar Ray, Sushant Bagaria, Shivani Shah, Subhashish Podar, Amit Saha, P.S. Chaudhary. So therefore 3 lakhs.
No, my lord. They are all by 50,000. My lord.
Reasonable.
And my lord,
did he not show him that as per what is that section 107, 108?
10%, my lord.
Huh?
10%.
10%. You
10%,
should have.
my lord. It would come, my lord, 1,10,000.
He was ready and willing to pay.
And my lord, here, my lord, what happened? If your lordship kindly permit me for 1 and 2 minutes, my lord. Here, my lord, I am challenging.
No, we will say that we will just modify paragraph 7, directing the appellant to pay 10% of the disputed tax as provided under section 107 of the Act. And upon compliance, the matter will be taken, appeal will be taken.
And my lord, bank attachment may be lifted, my lord.
That is already there. This intra-court appeal by the writ petitioner is directed against the order dated 1/10/2024 in WPA 21478 of 2024. Mr. Himanshu Kumar Ray, learned advocate for the appellant, would submit that the appellant is not aggrieved by the direction issued in paragraph 8 of the impugned order, by which the learned single bench directed the order of attachment issued in form GST DRC 13 dated 24/7/2024, but is only aggrieved by the direction issued in paragraph 6 directing the appellant writ petitioner to make a pre-deposit of rupees 3,00,000,000, which is over and above 10% of the disputed tax, which is statutorily required to be pre-deposited for preferring an appeal. Since the statute prescribes a particular percentage, the same has to be adhered to by the assessee, and under normal circumstances, the court will not alter the amount to be deposited. But however, in certain exceptional cases, the court may exercise discretion and direct payment of a portion of the disputed tax. However, the instant case does not fall under any such exception. Therefore, we dispose of this appeal by slightly modifying the direction issued in paragraph 7 of the impugned order by directing the appellant writ petitioner to pre-deposit 10% of the disputed tax instead of rupees 3 lakhs within a period of 10 working days from the date of receipt of the server copy of this order, and files an appeal electronically with the appellate authority. The appellate authority shall dispose of the appeal after affording an opportunity of personal hearing to the authorized representative of the assessee within a reasonable period, preferably within 8 weeks from the date on which the Procedural hearing is concluded. On effecting the pre-deposit of 10% of the disputed tax in terms of the above order, the respondent number 6, the order of attachment issued in Form GST DRC 13 dated 24th July 2024 shall stand revoked, and the appellant writ petitioner shall be entitled to operate his bank account. In the event the appellant fails to comply with this order, the benefit of this order will not inure to the appellant, and the appeal would stand automatically dismissed without reference to this.
My lord, subject to correction, my lord, appeal will be hard on merit, my lord.
Merit, yes.
One line maybe added.
Yes, sir. Had and decided on merits and in accordance.
Next. Item number 13.
My lord, item number 13, my lord. This is refund matter, my lord. With greatest respect, my lord, learned single judge admitted the writ petition and gave direction for exchange of affidavit. And my lord, no amount refund granted, my lord. Here what
Obviously,
happened?
no, if refund is granted, it will amount to allowing the writ petition at the admission stage. And what is the impugned order you have challenged?
My lord, I am challenging here, my lord, appellate order at page 213, my lord. Here, my lord, what happened in appellate order? The appellate authorities have written that tax invoice not submitted. For this reason, only rejected the appeal.
Against this order, you got a right before the tribunal.
No, my lord, GST, my lord.
Oh, GST tribunal.
GST, my lord. Appellate order. No, tribunal not constituted, my lord. And in the appellate order, my lord, written that he has written that some documents
Mr. Ray, that will be considered after the affidavit is filed. We will all request Mr. Siddiqui, senior advocate, to direct the department to file the affidavit earlier.
Expeditious hearing, my lord. My refund is lying, my lord, there.
All right. This appeal by the writ petitioner is directed against an interim order by which the learned single bench directed affidavit in opposition to be filed by the department within the time frame. The learned advocate for the appellant would submit that no direction was issued for sanctioning the refund. Such order could not have been passed by the cannot be passed by the learned single bench, since the refund application was rejected, confirmed by the appellate authority. And therefore, unless and until the appellant writ petitioner succeed in the writ petition, the question of refund would not arise. Therefore, there is no ground made out to interfere with the impugned order. Accordingly, appeal dismissed. The respondent department is directed to file their affidavit and opposition within 3 weeks from date. After reply, if any, within 2 weeks thereafter. Let the matter be listed before the appropriate learned single bench in the week commencing 6th of January 2024.
And liberty to mention, my lord, there.
You have said 6th of January, you do something. We can't say this thing and that.
I'm grateful, my lord.
Yes,
item number 14.
Lordship, I appear virtually in item 14, Lordship.
Yes, sir.
Lordship, this is a case wherein my ITC has been disallowed on the ground that there was retrospective cancellation of my suppliers. During the course of adjudication, Lordship, there are 3 impugned suppliers. I have shown their return filing status that they have filed all the GSTR 13B. I have attached all my invoice copies and Weybridge slips, which shows the vehicle number, and only after June 18, Waybill was introduced in West Bengal. So after the transactions of June 18, we have also attached Waybill copies. And we have
these are all factual details, Mr. Kanodi.
Lordship, the adjudicating authority writes in one line that the documents are insufficient. Lordship, we relied on Suncraft.
Authority will go through the documents.
Lordship, Suncraft judgment has not been court. We load for Suncraft that you kindly give us the report of investigation. What is the basis? And Lordship, all the judgments. Lordship, in fact, your Lordship in earlier matter was referring to some judgment. Recently in GST, Lordship kindly takes page 236. The Honorable Division Bench of the Guwahati High Court. The Honorable Division Bench of the Guwahati High Court, Lordship, in similar circumstance, has disposed of batch petitions, wherein they have referred to the Supreme Court judgment of Quest purchasing and stated retrospective cancellation of the dealer cannot disallow credit in GST also. Page 236, Lordship, operative para.
No, the retrospective cancellation, there are a lot of decisions, sir.
Lordship, I have attached, Lordship, DY Betal, page 213 is the Madras High Court, Lordships. Lordship, without any investigation of the supplier, and the portal shows that they have filed their returns, they have made the payment.
No, Mr. Kanodia, you please give this Vinayaga agency to Mr. Khan.
Lordship, I will. I was opening my screen that time, but because the matter was going on, therefore I didn't interpret.
And there is another decision also. This is by Justice Sudhakar. That is also by Justice Sudhakar. And
Lordship, in fact, your Lordship judgment at page 226, Shraddha Overseas, wherein your Lordship had kindly stated in para number 7 that retrospective cancellation cannot disallow the credit to the purchasing dealer unless collusion is proved at that time, because at that time it was a valid transaction. Lordship, without putting me to any notice.
All right, then we'll hear the appeal.
Lordship, they have issued, in the meantime, they have issued me recovery notice on.
No, that we grant stay. This appeal by the writ petitioner is directed against an order dismissing the writ petition challenging an. The learned advocate for the appellant vehemently contend that the decision of the adjudicating authority is clearly contrary to the law laid down by this court in several decisions, and as well as the other the decisions of the other courts, other decisions of the division benches of the other courts. The question which would arise for consideration is whether the decision of this court in Suncraft Energy Private Limited 2023 SEC Online Calcutta 2226 would apply to the facts and circumstances, and whether the retrospective cancellation of registration was valid in law in the light of the decision of the division bench of the High Court of Madras in Sri Vinayaga Agencies Manu/TN/1386/2013 and the recent decision of the division bench of the High Court of Guwahati in National Plasto Molding versus State of Assam 2024-21 Syntax 182 within bracket Guwahati. Therefore, this is a full stop. Since legal issues have been raised in this appeal, we are inclined to take up the appeal for hearing at this stage, without insisting upon filing of paper book. Since notice of demand has been issued on the appellant SSC, the department is directed not to initiate any coercive action against the appellant SSC or enforce the notice of demand which has been issued. Let the appeal be listed under the same caption. (17th December).
17th December.
Get
Next.
Item number 15.
Yes, sir.
Madam, for the response. Lordship, I am appearing on behalf of the appellant. This appeal is challenging the order passed by the learned single judge dated 25th November 2024. Lordship, before going into the order,
that we saw, all writ petitioners were granted license for temporary occupation of the railway land sometime in 2011. The license clearly states that if they want the land, 1 month notice has to be given.
Lordship.
It is not a lease. You don't have any vested right. It is railway land which was lying vacant. At that time, they thought 200 square feet, you can run a shop, etc. Now, what is your ground of challenge?
I like to point out a few factual aspects of this case. That is, in the month of December 2023, the railway authorities issued a notice for eviction under the unauthorized Eviction of Unauthorized Occupants Act 1971.
That is not required. Under the Railways Act, I think 127.
147, my lord. Lordship, but the notice was never issued under 147 of the Railways Act.
We will ask them to issue, grant you reasonable time. See,
Lordship,
the thing is,
one more
business.
aspect, Lordship, I will beg before your Lordship to consider.
Don't beg, submit. Nobody should beg. Huh? You make your submissions.
Lordship, here I am begging because it affects the livelihood of the poor people, and they have been working there running the shops for the last 40 years and above with the permission of the railway authorities.
That is why
Now
we
they
are
are not
saying
claiming.
you are not a trespasser. You are not an encroacher. You are a licensee of the railway. Now, license is not automatically renewable. It is not a lease. It doesn't confer a right over the land. You know the famous decision, 1971 Supreme Court, distinction between lease and license. Law school days you would have been taught. So therefore, you don't have any vested
Also,
right
I
over
would
the
like to point out a celebrated judgment of the Honorable Apex Court, that is Olga Tellis.
Volga Tellis is different.
This is
We
where
will grant you, subject to what the learned senior advocate will say, reasonable time. Because
Lordship,
it is public property.
They already been evicted, my lord, and kindly see
Evicted,
that. Yes, yes. Because it was expired. The license was expired, my lord, long back.
the order was passed on 25th. They within
And my lord,
1
kindly
week
see
they
para 7 of
evicted.
the order. Para 7 of the impugned order. Order under challenge. Lord, after the project is over, they have given liberty to approach us. Lord, kindly see para 7.
All right. We have heard the learned advocates for the parties. Though the writ petitioner, appellant writ petitioners are stated to be licensees of the railways and permitted to occupy a small extent of land for putting up.
Lordship, one small submission, if your
shop.
Lordship allow. Lordship, instead of this sympathetical view, if a direction is given to rehabilitate them, because they have already in their development plan, they have shown spaces where they are proposing to build commercial
They'll
shops.
do it. The development plan is at page 157. Correct? No, all right. You strike out that. This intra-court appeal by the writ petitioner is directed against the order dated so-and-so and WPA number so-and-so, by which the appellants had challenged the eviction proceedings initiated by the railway administration. Admittedly, the appellants do not have any vested right over the railway property, though they were granted a license to occupy a small portion in the year 2011. The terms and conditions of license clearly stipulate a method for termination. Full stop. The settled legal position is that a license is not automatically renewable, and there is a clear distinction between a lease and a license. What was granted to the writ petitioners was a license for temporary occupation of the railway land. The land is now required for a public purpose. The learned single bench found no merits in the contention raised by the appellant writ petitioner. We also fully subscribe to the view taken by the learned single bench. Apart from that, the learned single bench has also taken note of the fact that there is also a proposal for rehabilitation of the writ petitioners / licensees by the railway administration. Therefore, we find no grounds to interfere with the impugned order. According, the appeal is dismissed. We direct the railway administration to consider the cases of the licensees as and when they draw up a plan for rehabilitation. And such consideration should be in accordance with the
Lordship, affidavit of service may be taken.
Item number 16.
Affidavit of service taken on record.
I'm appearing for the appellant, your Lordship.
What is
Lordship, on the last occasion, there was a direction, my lord, to file affidavit in opposition in respect to the writ petition. My lord, the writ petition, my lord, the opposition is yet not ready because, my lord, the registrar of these presidency small causes court, my lord, has joined, my lord, new incumbent has joined, Lordship. We need some instructions on that. My lord, the point that was taken in this appeal was that what would be the date of the promotion of the writ petitioner?
Pranav, you remember we heard the matter elaborately and
Lordship.
then only we directed. Because Mr. Ray has been mentioning the matter, the client is
Lordship.
suffering. When you will file the affidavit?
Lordship, within a week, Lordship. Within 10 days, Lordship, I'll be filing.
The time for filing affidavit in opposition
Respondent
is
number
extended.
1, Lordship. That respondent number 1, that is a writ petitioner, has also died. That I have already intimated to the appellant.
Then
And
you will bring them. Then you have furnished the legal heirs details.
Lordship.
Yes, I have already given the names of the.
Then you file an application for substitution.
Lordship, I vote.
Time for filing the
And one
affidavit
thing
in
more that
opposition is extended by 10 days from date. Since the first respondent writ petition is no more, and the details of the legal heirs have already been furnished to the appellant, we direct the appellant to file an appropriate application for substitution of the legal heirs of the deceased first respondent writ petition. Yes, Mr. Ray, what do you want to say?
Another thing is what my learned friend has just now said, that judge in charge, he has also appointed for the post for the registrar. He can also be filed the opposition or taken the steps
Yes,
on
Your
behalf
Lordship.
of
New
the
incumbent has joined.
judge or transfer judge. So there is no scope for they at least on the before 19 it should be filed, but they have not filed within that time.
All right, what to do? Transfers are all incident and conditions of service. Next,
Lordship, since I was not there in the writ petition, that is why I thought some instructions.
No, you sit with them immediately, ask them to come over, discuss.
Lordship.
Don't write
Grateful
letters
to
to them. Don't write letters to them.
I'm grateful to you.
Item number 17.
This appeal arises from order passed in Group 6.
Lord, I'm appealing for my lord the appellant. Here the question would be as to whether a promotion which has been given would be construed to be a promotion given with a retrospective effect would be construed to be within the ambit scope and ambit of past service. Now, my lord, the appellant before a lordship is an LDC. He was initially recruited in Bakura under the judgeship. Thereafter, my lord, he was confirmed.
And who will appear for the state?
My lord,
I beg to defend the state.
Mr. Banerjee is appearing and Mr.
Alright,
State is appearing. My lord.
I am representing
High Court Administration.
Very good. Now paper book has been filed, so we'll have to hear the appeal.
My lord, it was being heard, my lord, on day-to-day basis before the previous bench, my lord. Very short point, my lord. Today, what has happened?
No, wait, Mr. Lahiri, which previous bench heard the matter?
The Honorable Justice, my lord, Devanshu Bosak, my lord.
All right. We have heard the learned advocates for the parties. As could be seen from the order sheet, this appeal was substantially heard by the Honorable Division Bench presided over by Honorable Justice Devanshu Bosak. In the light of the same, we deem it appropriate that the appeal should be released and the papers be placed before the Chief Justice for necessary orders, so that you can save on time.
My lord, deeply grateful.
Next
Next matter, my lord, I'll be praying for time, not yet, my lord, prepared.
Item number 18.
Only not today, my lord, in the next matter.
This is judicial officer, is it?
Yes. This was not heard previously before any other bench.
All right, we'll hear it. What is this? Promotion, punishment?
My lord.
District Judge, district judge on the issue which falls for another judicial secretary.
Increment 29 petition are not yet.
Increment of what?
Increment of as per city commission. Implementation of city.
My lord, this is, my lord, in respect of several employees, an increment.
Actually, Justice Mukherjee has said that there is a anomaly committee which has been formed.
Yes.
And the matter has been referred to the anomaly committee. I think the chairman is Honorable Justice Joymala Bakshi. Why can't we place it? We'll do something good for them if it is permissible.
And he keeps it in the list, my lord. This is really for expedition if your lordship expedites.
I represent the district judge, my lord.
I
represent the concerned district judge, my lord. Only difficulty we are facing is that the city commission permitted switchover of the stenographers to the ministerial post.
All right. No, wait. We will find out. This intra-court appeal is directed against an order passed by the learned single bench, which has adjourned the matter sine die, which has adjourned the petition sine die on the ground that the matter has been placed before the Honorable Anomaly Committee to consider the issue. We find no error in the order passed by the learned single bench. The learned advocate for the appellant would submit that there are several writ petitioners, several persons who are likely to be affected on account of the difference in pay scale.
They have been given, my lord. We have not been given. Several
difference
persons similar circumstance has been given.
and that several and it is submitted that the several similarly placed persons have been extended the benefit. Since the matter has been placed before the Honorable Anomaly Committee, we are not inclined to interfere with the impugned order, and the writ petition shall be kept pending. Pending.
Kindly keeps the appeal also, my lord.
No. And
Let us file some paper book or something so that we can come up and say before your lordship, my lord.
I will do something. And
I'm appearing for the High Court administration. But probably I have instruction that this committee should not is not called an anomaly committee. Lord, maybe it is a committee which is looking after the Shetty Commission's recommendations, my lord.
Okay.
Liberty to approach the committee, my lord, then.
Wait, sir. Mr. Lagri, the court doesn't function that way. It is submitted by the learned advocate for the High Court administration that the committee before which the matter is now being dealt with is not the Honorable Anomaly Committee, but the Honorable Committee dealing with issues arising out of Shetty Commission recommendation.
My lord.
Therefore, the appeal stands disposed of on the above terms. So I will do something tomorrow.
Certain time.
My lord.
I will do something tomorrow. Tomorrow.
My lord, deeply obliged. Deeply obliged.
This is all for today, my lord.
Yes, sir. We'll stop with this, sir.
All right, my lord.
Thank you.
21. If your lordship kindly takes step any day, item number 21. This is the contempt from my lord's order 28th of February.
Yes. Where is Mr. Siddiqui? He was here.
SLP has been dismissed without interfering, so lordship, they have to pay.
Yes, they have to pay. Where is Mr. Siddiqui?
Mr. Siddiqui is taking advantage of his personal knowledge that how many files have reached my lord's chamber. So,
No, he'll take it out of turn. They will share soft copy and we'll issue notice of contempt.
He's standing outside. I saw just now.
Please invite him. No, he has to appear after designation. He has to appear as for the contempt.
Yes.
Please call him.
Mr. Siddiqui he's outside. I'm just calling. His junior and he were both there. Yes. He's coming. He's coming. Yes, there is Mr. Siddiqui. I can see. Sure. Get up. The Siddiqui you can't avoid.
We are not avoiding. We are not avoiding.
All right, problem.
We have filed a review application before lordship after the Supreme Court's order, no doubt about that. But it is not appearing in the lordship's list. We are giving the number.
Okay. We have heard the review application. We find no grounds to entertain the review. Review dismissed.
that my lord, the writing is on the wall.
What is all this, sir?
Supreme Court has given reasons.
We saw that order. Somebody mentioned Mr. Mitra before one of his juniors mentioned.
Lordship, kindly takes up both this matter.
All right. It is we have heard so also. It is item 21 you placed take down. It is submitted that as against the judgment in MAT 1965 of 2022, the specially petition filed by the state has been dismissed. It is submitted by Mr. T.M. Siddiqui.
SLP filed by WBIDC, my lord.
Both. State also filed.
Two state and WBIDC have been dismissed.
Yes.
It is submitted by Mr. T.M. Siddiqui and a senior advocate appearing for the state. That review application in the RVW so-and-so number has been filed. List the contempt application along with the review application in the admission list higher on board next week.
Grateful.
You serve note grounds of review. We'll stop with this, sir. Grounds of review, you please serve.
Yes, that is. They have to serve us.
We'll serve them. We'll serve them.
You serve it today itself.
We'll serve it today.
No, we have not been served.
All right. We'll stop with this, sir.
All right.
Thank you.
Before your lordships rise, my lord, may I just mention, my lord, item 22, my lord, it's a contempt application, but I'm not troubling your lordships today, my lord. I'm only praying, my lord, if the main PIL, my lord, out of which this order contempt application arises, my lord, if it could come up under to be mentioned, my lord. Why, my lord? Because the health.
No, what we can do is we can get the PIL along with this contempt.
My lord, I'm grateful.
So list item 22 next week along with the writ petition, namely WPA P322 of 2021.
Lordship, I'm grateful, my lord, to be mentioned.
Yes, sir.
Item 33, lordship. I'm
That
praying
is that
33, lordship. If it can be taken up in January, lordship.
That is, Supreme Court is already the other matters are you said no that elephants have been dealt with very
Lordship,
badly. That Supreme Court has issued notice to the state of West Bengal.
That is for the death by the burning shoe.
Yes.
Only that one, lordship.
But in fact, one of the grounds in your writ petition is also that.
I have checked up, lordship, but I'll again check up, lordship. Lordship keeps it in January. I have seen it. It is only for the with the fire.
But then you can do one thing because you are an enthusiastic person, and why don't you intervene in that proceedings also? We'll keep your matter in January. You intervene there. You can appear online.
It's Prerna Singh Bindra's matter. We are more or less in keep a track.
You can give some details, no? So you can give the petitioner some more details with regard to these elephants, how they are dealt with in state of West Bengal.
I will, lordship.
It's better that you intervene.
Lordship,
Mr. Ghosh is appearing online.
Yes, my lord. I'm mentioning item 55. Unfortunately, it's been 6 months. Mr. Kundalia has not filed his affidavit, and he's been designated. Congratulations to him.
He has been designated now. What to do?
So, my lord, I'm only praying that a direction may be given to them, foreclose their option, because 6 months no affidavit has come, my lord.
Let us see, because we don't know who will be the counsel on record now. Let it remain in the list. My court officer will inform Mr. Kundalia.
Lordship, item 33, then 14th of January, may I pray, lordship?
Yes, sir. 14th of January.
Deeply obliged, lordship.
My lord, may I pray in respect of my lord, item number 20, my lord, contempt, my lord's order. If my lord fixes on any day, my lord.
It will be there in the list. Who will have to, who's the advocate?
My lord, previously, I believe my lord, senior advocate Saptangshu Basu was appearing on behalf of the State Bank.
You can't serve on the senior advocate. Who was the counsel on record?
They have already appeared, my lord. They have entered their appearance, my lord, and on the last occasion, they have filed their affidavit in opposition as well, my lord.
Very good. Then let it remain. We'll take it up next week. Okay?
Deeply obliged.
Thank you.
All right.
Thank you.